to deliver the welcome address and formally welcome our guests.
Thank you, Dikshit ji. Uh, Honorable distinguished guests, all my dear students and esteemed colleagues present here for today's panel discussion on topic right to information, integral component of freedom of speech and expression. I am very happy and delighted and feel privileged to have distinguished guests among us. And I would like to give a brief about our center because, dear friends, as all of you know, that while Delhi University is celebrating its centenary celebration in the year of 2023, Law Center 2 is also celebrating its Golden Jubilee year 2021 and 22. We have already successfully organized number of programs, events, and activities, and, and now we are on our way to create a roadmap for the future generation. In the continuance of celebrating 50th Golden Jubilee year of Law Center 2, today we are adding one more event in our Jubilee celebration, Golden Jubilee celebration, that is panel discussion on topic right to information integral component of freedom of speech and expression. As all of you know, that Law Center 2 has a long, proud and distinctive history. It is one of the distinct center of Faculty of Law, University of Delhi. Law Center 2 was founded in the year of 1971 at the premises of URSD College, Kolakua, to provide quality education while offering full-time LLB program. Today, Law Center 2 is a Golden Jubilee Center, continues to be a progressive center and made a strategic commitment to the higher quality of teaching and research. It is a premier institution and is known for its qualitative teaching, research, and other co-curricular and extracurricular activities. The center is a hub of research and learning for law students to promote students' activities at the center. A number of committees have been constituted like moot courts committee, debate committee, seminar committee, journal committee, legal aid committee, placement committee. And here, again, I don't, hesitate to mention that our center, Law Center 2, had the privilege of being headed by the top law scholars of India, such as Professor Upendra Bakshi, Padam Shri Awadi, a well-known jurist and former Vice Chancellor of Delhi University, Professor Tahir Mahmood, who subsequently became a chair person of Minority Commission, Professor A.K. Cole, who was elevated as Vice Chancellor, NLU Jodhpur and NLU Ranchi, Professor Gurdeep Singh Bhari, who became Vice Chancellor, NLU Lucknow, Professor B.T. Cole served as chairperson, Delhi Judicial Academy. Professor Poonam Saxena is presently Vice Chancellor, NLU Jodhpur. Law, Law Center 2 has the privilege of having alumni from all walks of life. As Law Center 2 is celebrating 50 years of teaching, the center has grown exponentially in footprint, academic offerings, and students' body. Today, number of alumni of Law Center 2 are contributing in the future of India. Alumni includes senior bureaucrats, police officers, revenue officers, doctors, engineers, chartered accountants, company secretaries, politicians. Some of its alumni include His Excellency Honorable Governor of Arunachal Pradesh, Brigadier Sri B.D. Misraji, Sri K.J. Alphonse, Member Rajya Sabha, Ex-Minister of State for Tourism, Justice E.D. Ahmed, Justice Kailash Gambhir, Justice S.N. Dhingra, Justice Rajiv Sankadar, Justice V.K. Rao, Mr. M. Damodran, Mr. G. D. Geha, Professor Manoj Kumar Sina, Director, Indian Law Institute, New Delhi, among many more legal luminaries. Law Center 2 has been publishing two journals named National Capital Law Journal and Delhi Journal of Contemporary Law, publishing quality research papers in the field of law and contemporary. So today, as all of you know, that we are adding one more program in the celebration of our Golden Jubilee, and today we are having uh, very distinguished guest. It's our honorable and very uh, renowned and distinguished guest, our own Honorable Sri Suresh Chandraji. Suresh Chandraji has been functioning as Information Commissioner in Central Information Commission since January 2019. Prior to this, he served as a Union Law Secretary for over 2.5 years, an officer of the Indian Legal Services. He has worked as the Additional Secretary and Joint Secretary in the Law Ministry, has dealt with administration and judicial sections and rendered advice to the various ministers. He has led a number of Indian delegations at various international fora and was a patron of Digital India program launched by Honorable Prime Minister on 2000 on 2nd July 2015. He successfully implemented numerous IT related initiatives in the Department of Legal Affairs, like Legal Information Management and Briefing System, National Data Sharing and Accessibility Policy, e Office, Online Notary Public Application, Content Management Framework, etc. He has been conferred several awards, notably the Scott Award for Achievement of Digital Monitoring of Court Court cases through LIMS, and on 23rd June 2018, and the National Law Day Award for outstanding achievement in the field of law. He has contributed articles in reputed Journal of Law and has delivered lectures and talks at prestigious institutions. Sir, I'm really thankful from the bottom of my heart, and again I welcome you at our center or in the family of Lesson Two, and welcome you from the core of my heart. Thank you, sir. Thank you, sir, for joining us. And again, we would like to have you in future also, because you had been remained a part and parcel of LC2, because as and when we requested you, you gladly accepted our invitation. So we hope and expect in future also. So again, I welcome you, sir, at LC2. Next, today's speaker, it's our own Dr. Varun Chachar. Varun Chachar is a proud alumnus of Law Center 2 and currently serves as Associate Professor of Law, Coordinator, Dr. Sankardal Institute of Democracy, Director, RTI Cell, and Assistant Dean Students Welfare of University of Lucknow. He specializes in the area of constitutional law, interpretation of statutes, right to information, public policy, and governance. He has a rich teaching experience spanning more than 11 years. He has previously worked as Assistant Professor, Law Center 1, University of Delhi, and Assistant Professor, Faculty of Law, University of Lucknow. He is the author and editor of four books and has contributed chapters to various national and international journal publication. He has an excellent publication profile and has published several articles in Journal of Repute. He is a distinguished speaker and has presented papers at national and international conference. He is a reviewer of Sheikh, India, and serves as a member Department Research Committee, Department of Law, Dr. Ram Manohar Lohia, Awadhi University, Ayodhya. He is also a member of editorial committee of MSP Global Law Journal, Maharaja Sujamal Bridge University, Bharatpur. I welcome our own beloved alumni in his own family of Law Center too. Thank you, Varun, for joining us. And I pray to God, kindly, you will be getting your highlights and you will be touching the sky because there is no limit in sky. So please keep it up. Thank you.
Thank you very
Over
much,
to
sir. Thank you very much, sir, for your opening remarks and for setting the tone for today's program. You have, while also giving wonderful brief about the center, you have also introduced our guests before the audience. And with these words, I will request Suresh Chandra sir to take over the virtual dais and speak to us about the topic, which is right to information, which is a fundamental aspect of the freedom of speech and expression. So, sir, I will request you to share your scholarly words with us, after which we will request Dr. Varun, and then we can have a round of question and answers from the audience. So, please, sir.
Thank you. Thank you, Professor Mahavir ji. Thank you, Professor Parikshit ji. Respected Dr. Mahavir Singh ji, Professor in charge, Law Center 2, Delhi University. Dr. Parikshit Sirohi ji, Professor, Delhi University, who has been the instrument and the man behind bringing us together on this important topic. It shows his love and affection to the topic as well as to the people who are connected today. Our beloved writer, intellectual, associate professor, faculty of law and director RTI, Professor Varun Chacharji, respected audience, dear students, ladies and gentlemen, welcome to the webinar on a very important topic, that is the right to information, an integral component of the freedom of speech and expression. Parikshit ji, am I audible? Is it okay?
Yes, sir, you are loud and clear, sir.
I am delighted to be part of the deliberations on such an important and relevant topic. Without taking much time, I will come straight to the subject, but I shall be failing in my duties if I don't draw your attention to the preamble of our Constitution, especially to its central theme, that is the theme of justice, liberty, and equality. Here we are more concerned with the concept of liberty. How important is the liberty for a democratic country, for the open society, and for our country? I leave it to the other panelists, especially Dr. Varun Chacharji. Liberty, as we understand, includes a very vast area. It's a broader concept. In this concept, we are concerned with the freedoms, though the liberty is a broader concept. And when we talk of the freedoms and as enshrined in our Constitution, then in the Constitution, under the heading freedoms, these are the articles right from Article 19, 20, 21, 23 up to Article 30 of the Constitution. But again, we will restrict our discussion to the Article 19(1)(a), that is the right to freedom of speech and expression. Here I am giving more stress and emphasis on the right to freedom, because there are six freedoms, rights in under Article 19(1). However, right to freedom is only in Article 19(1)(a), that is the right to freedom of speech and expression. When we say the freedom of speech and expression, it has a definite connotation. It guarantees the freedom of speech and expression, but it is not that it is without limitations. It is unlimited. It is not that there are two phrases: right to freedom of speech and expression, and the speech and expression. Here, what is guaranteed is the first one, not the later. That is right to freedom of speech and expression, which means that it can be curtailed only by by the law made by the Parliament under Clause 2 of the Article 19. And these are definitely, makes this right very important, to the extent that it is more important than the other 6 rights, and it precedes all other 5 rights. Just to bring about the evolution of the right to freedom of speech and expression, I will discuss some of the court cases, some of the pronouncements by the Supreme Court, right from the Ramesh Thapar versus State of Madras up to the Secretary Information and Broadcasting versus Cricket Association of Bengal. And how a right which was only right to express, to have views, also how it has evolved to have the information. Way back in 1950, this matter came before the Supreme Court when under the Madras Maintenance of Public Order Act 1949, His Excellency the Governor had prohibited one English weekly, that was the Crossroads. And the petitioner, who was a publisher, he challenged that on the ground that it has this particular order, which was issued under the Madras Maintenance of Public Order Act 1949, violated his fundamental right. And the Chief Justice Patanjali Sastri, while striking down that provision, not only the order but also the provision, held that freedom of speech and of the press lay at the foundation of all democratic organizations, for without free political discussion, no public education, so essential for the proper functioning of the process of popular government, is possible. A freedom of such amplitude might involve risk of abuse, but the framers of the Constitution may well have reflected with Madison, who was leading spirit behind preparation of the First Amendment of the Federal Constitution, that it is better to leave a few of its noxious branches to their luxuriant growth then by pruning them away, injure the vigor of those yielding the proper fruits. Now, before I come to the right to information, I want to just bring out that the law as it has been enacted in 2005, way back in 1975 in Raj Narayan, in state of Uttar Pradesh versus Raj Narayan, Supreme Court had said people of this country have a right to know every public act, everything in a public way while they are public functionaries. Likewise, in the Union of India versus Naveen Jindal, the nationalism, patriotism, and love for the motherland, the use of national flag by way of expression of those sentiments would be a freedom. Now, I mention this because I was the person, I finalized the draft counter to object to that on the basis of the guidelines the Ministry of Home Affairs has for hoisting the flags, national flags and all. But the Supreme Court has very categorically have said when somebody could even hoist the flag in America, but in our own country we were prevented from hoisting the flag. The most important case, if somebody asks me, is the Maneka Gandhi versus Union of India, wherein not only you see the interoperability of all these articles was established. Earlier it was considered that these were the state jacket formulas and independent rights were contained under independent articles. They had said that there is a common thread in these, and they had said that not only there should be a law, the law should be reasonable, just, fair, and reasonable. And there also they had highlighted the democracy. They had said that democracy is based essentially on free debate and open discussion, for that is the only corrective of the government action and a democratic setup. If democracy means of the people, by the people, and for the people, it is obvious that every citizen must be entitled to participate in the democratic process. And in order to enable him to intelligently exercise his right of making a choice, free and general discussion of public matters is absolutely essential. In this, apart from all these ideas and the evolution of this right, there were developments worldwide, and I would like to quote one of the judgment, Whitney versus California, wherein way back in 1927, Louis Brandeis made a classic statement on freedom of speech in the context of US Constitution. Quote, those who won our independence believed that the final end of the struggle was to make men free, to develop their faculties. They believed liberty to be the secret of happiness and courage to be the secret of liberty. They believed that the freedom to think as you will and to speak as you think are means indispensable to the discovery and the spread of political truth. That without free speech and assembly discussion would be futile, that public discussion is a political duty, and that this should be a fundamental principle of the American government. Talking about the First Amendment in the US Constitution, which guarantees freedom of speech in the USA, the US Supreme Court in Associated Press versus United States 1945 has observed It is the purpose of the First Amendment to preserve an uninhibited marketplace of ideas in which truth will ultimately prevail rather than to countenance monopolization of that market, whether it be by the government or by the private licensee. Here I am highlighting, I am emphasizing more on this. On a similar lines, in the Secretary versus Secretary Information and Broadcasting versus the Cricket Association of India, the same thing they have said, that monopolization by the sports association cannot be allowed. Not only they have the right of broadcasting and telecasting, the airwaves being in the public domain, the people, the persons who want to learn the sports technique and education, they also have a right to know. So that is how the right to have information from the public bodies or from the public authorities had emerged. And finally, it was in the matter of the PUCL versus Union of India in 2003, wherein the one amendment which was made in the Representation of the People Act, Section 33B, was struck down by the Supreme Court, holding that it is illegal, which provided that notwithstanding anything contained in the judgment of any court or directions issued by the Election Commission, no candidate shall be liable to disclose or furnish any such information in respect of his election which is not required to be disclosed or furnished under the Act or the rules made thereunder. Now, the Supreme Court, while striking down this particular provision, said that the conferment of right to vote cannot be exercised without a right to choice, and that choice cannot be made unless you are giving full information. That is how, through all these judgments, if we take by the year 2005, the law was already there. Right to have information from the public authorities was very much there. But what was not there, if somebody asks me or somebody, questions that everybody has a right to speak, but they cannot have the right to get the information. A common man, normally what happens, Varunji, what happens, majority of people, they don't know what the law is. It is already in the Supreme Court rulings. There are so many laws, but nobody knows it. Nobody knows their rights. They come to know only when it is enacted and published. It is given a wide publicity. So there are 2-3 things which the Right to Information Act has fulfilled. One of the wide publicity, and another one is the mechanism. It has provided a mechanism. Central Information Commission, State Information Commissions, how to file an RTI, how to preserve the information catalog, easily to be retrieved and all that. So when we say it is a component, it is already there, but a lot of people don't understand and don't know. Now, having said that, now I would like to discuss the provisions of the Right to Information Act, which is directly, which is definitely a component as have been brought out in the subject, in the topic. As we people, understand there is a different stream, administrative law. But if you see, administrative law is nothing but a part of the constitution, the governance, the rules of governance. So I will take very, cursory look at the provisions. If we see the whole RTI Act, it has 5 components. One is the practical regime of RTI, which is the constitution of CIC, SICs, and also the appointment of CPIOs, and all those practical regime which has been created, including the investigation, punishment, second appeal, and all that. Second aspect, second component which I see is that it is available to the citizens. Applicable, as have been said in Muhammad Anwar's case, Anwar versus J&K, way back, that the rights under Article 19(1) are not available to the foreigners. And also in RC Cooper versus Union of India, when it is a bank nationalization case, the Supreme Court had said that state action may impair the right of the company, may impair only the rights of the individuals, and it may impair the rights of both. But the jurisdiction of this court cannot be denied to the persons, to the individuals, only on the ground that the rights of the company have been impaired. So this is very important. And under RTI also, when we are hearing, when somebody says that he is asking, or somebody is asking on behalf of one company, or on behalf of a society, organization which is not citizen, we are insisting upon, if somebody by name, being an authorized person of that company, seeks an information, then we are denying. And already, law has already been laid down in this. Then the third component, which I see, is the public authority. And when I see the definition of public authority contained under RTI Act, that has been drafted in such a way that it encompasses all those evolutions which had happened in the definition of a state under Article 12 of the Constitution. Right from Som Prakash, right from Savajit Tiwari case, Mohanlal versus J&K, and what you call Ajay Hasia, the instrumentalities, the financial control and other controls, institution notification made by the government like ICAR, and all those. So what is required here also in the public authority, reason being that the applicant can claim only against a public authority. I cannot claim as a matter of right from Dr. Parikshit Sirohi. He will say, how are you concerned? So here it is necessary that we have to make a distinction that public authorities are only liable to disclose and maximum disclosure as per section 4(1)(b). So this is again against the public authority. Then it promotes transparency and accountability. This concept is very important, and that is the reason, the philosophy behind bringing out this provision. And that is, we are a democratic republic. As I had mentioned about that case, Maneka Gandhi's case, we the people, by the government, by the people, for the people, of the people. Then the information which is contained in the public authority, in the custody of the public authority, everybody has a right to have it, provided it is not otherwise exempted under section 8. But as we have seen, every right is not unlimited. It is limited by the public interest, disclosure. In the case of Article 19, it is by the it can be curtailed only by law made by Parliament. In this case, under RTI, they have already brought out the grounds under section 8, A to J, and these are little more than what are contained in our section 19(2). Reason being, here you are seeking the information from public authority. So there is a balancing. Balancing means harmonizing both the interests, the public interest in disclosure and public interest in withholding the information. Otherwise, the efficient operation of the governments or the unwarranted burden on the public exchequer, use of fiscal resources, or the confidentiality of sensitive information will be violated. That's why these are the components. I will not go in more details because everything has already been, my co-panelist will discuss, but I shall be failing in my duties if I do not mention that in the RTI Act, apart from the public authority being the custodian, an individual can have the information if public authority can seek information from the private source, private bodies, in the form of certain returns, in the form of certain, likewise, lot of returns, audit reports, inspections are being done by Reserve Bank of India, of the private sector banks. An individual can seek that information. Lot of informations are being collected by various public authorities like RERA, like town planning, these bodies, wherein lot of data is being collected by them. So they can seek certain estimates, certain other details of their builders and all those architects and all that. So this is something which is more in the case of the RTI. So these are the components of the RTI. Apart from that, there is a provision for inspection, investigation by the CIC, wherein their orders or the RTI is not being properly implemented. So the power of punishment is also given, limited up to 25,000 rupees in one go. And the appellate powers are always there. Review power is not there. Prior to us, the review was also being indirectly was being done. That has been done away now. there were there were certain, it happens at times. So then there are certain organizations under section 24 which have been exempted, like CBI, IB, security, relating to the security or economic interests. And all this is the whole RTI Act, and definitely it is very much within the Article 19, and definitely it is a component. Article 19 again is a broader one. This is little part of that, a component, very rightly mentioned by Dr. Parikshitji. And with these words, I conclude my talks, and I will welcome when there will be question. That Dr. Varun Chachar should take over now with the permission of Parikshitji. Thank you very much.
Thank you very much, sir, for your wonderful address. And in fact, we were just when we wanted to organize this program, I was very keen that when I was discussing with Professor Mahavir Singh sir, that we should be having this program in this semester. So our current semester, we are actually teaching Constitution Law 2, wherein we are teaching the fundamental rights, the entire DPSP. So when we are teaching fundamental rights, we are taking the entire Article 12, Article 19. So a lot of what you have already captured, it is very important actually from a practitioner's point of view, from a policymaker's point of view, what you have spoken about all these cases which are in our syllabus: Secretary Ministry of INB, R.C. Cooper, Menaka Gandhi, the trilogy of 14, 19, 21, Bennett and Coleman, then wherein they have accepted that the right to be informed is fundamental for. So from there you are having freedom of press. Administrative law, you have very rightly said, is actually a part of constitution law. We are also saying the same thing in different words, that it is the younger sister of constitution law. So then you have spoken so nicely about the concept of state. Som Prakash Rekhi we are teaching, Burma Shell case. Pradeep Kumar Biswas is in our syllabus, the Indian Institute of Chemical Biology. Z Telefilms we are teaching, BCCI that you mentioned. Ramanna Dayaram Shetty, the Airports Authority case is there. Sabajit Tiwari, which was overruled by Pradeep Kumar Biswas, the CSIR stenographer case. And Sukhdev versus Bhagat Ram, very interesting. The same day, the same bench has given two opposite decisions. Yes. So LIC, IFCI, and ONGC, they are not state, whereas here they have held it to be in one case state and the other case not state. So very interesting actually. So that is why it has been overruled in 2002. So thank you very much, sir, for your wonderful analysis as always. You also referred to
one moment, because I came to just I remembered all those things. In 1992, I was interviewed for Indian Legal Service, and at that time I was in the National Airports Authority of India. So I had studies. Studies this Article 12 of the Constitution, right from this up to that. At that point of time, when Sabajit Tiwari I had discussed, and they had said much water had flown thereafter, but they stopped just less because they did not want to overrule that.
Yes,
Sabajit Tiwari.
That's right.
And I had in my interaction, I had said that today if somebody files a review, it will be reviewed because now it is not a good law.
Correct.
And I was selected only because of that.
That is very interesting because, like I said, the same day, the same bench has said that LIC, ONGC, and IFCI are state, whereas CSIR is not state. And in 2002, they have changed their position. So very right.
And I have escaped so many judgments like Sakal papers, like
Express,
Indian Express, and all those cases. time is the constraint, and
No, we understand, sir.
we have
We
to
understand.
Dr.
We
Varun.
understand, and that means, sir, that we have to call you again for a full session. Physical, maybe this time, God willing, physical session. We will call you definitely, sir. So thank you very much, sir, for
Thank you. Thank you.
elucidating. And I'm sure if there are any questions, we will come back to, sir. I would now request Dr. Varun to share his perspective on the right to information as a tool for the freedom of speech and expression, because Dr. Varun is active in this area, and if you see his publication profile, he has written and spoken immensely about this. In fact, the topic of his PhD thesis itself is right to information. So over to you, sir.
Thank you so much, Dr. Parikshit. My sincere regards to the Honorable Information Commissioner, Shri Suresh Chandraji. My very profound regards to respected Professor Mahavir Singh ji, my teacher from Law Center 2. It is really a matter of immense pride for me today that today I'm speaking for my own center where I was student from 2003 to 2006. Really, I'm feeling, I'm not physical there, but still I can feel that difference.
We will call you, God willing, we will call you physically also.
Yes. So it's really an honor and a privilege. Sumiti ji, thank you so much. All the faculty members, and I can see some of my teachers, Professor Pinky Sharma ma'am, I think she is there, and
Professor Kiran Gupta madam.
Kiran Gupta ma'am, my teacher again, she is also here. So many, my teachers who gave me this opportunity today that I am sitting here and speaking on a very important topic, right to information. I think, it is a very, very important topic. Why it is? Because as a teacher of constitutional law and a teacher of interpretation of statutes, I think I believe in the context, the term context, because the context makes the difference. Chandra Saab rightly said, the preamble is the key. And when we dwell upon the preamble, let me tell you this fact that the preamble itself talks about very important aspect, and that important aspect is freedom. Now, liberty and freedom, both essential tenets, are mentioned within the domain of the Constitution of India in the preamble. Chandra Saab rightly said, we need to understand that deliberation, that liberty, and that is what has been upheld in Bennett and Coleman and Sakal newspaper. Freedom of press and liberty of press. Even the Supreme Court goes beyond its dimensional value, and that is why in Bennett and Coleman versus Union of India, the Supreme Court says so that freedom of speech and expression includes right to know, and that was I believe that was 1962 order which was challenged before the Supreme Court, and that order was that it was limiting the number of pages for the Bennett and Coleman company, and that was a starting point. How would people come to know what ought to be and what not ought to be? As a teacher of constitutional law, I sometimes wonder, policies have been decided, but when they've been decided, who knows how they've been decided? What are the file notings? What are the deliberations on the basis of which policies has been taken? This is something which is very, very important and essential. Taking this particular aspect into the consideration. Sometimes, I wonder, when we talk about freedom of speech and expression, and when we talk about right to know, then the plethora of judgments, we had when we started when we start this particular deliberation of freedom of speech and expression. There is a lot which have been said by the Honorable Supreme Court in Ramesh Thapar, in Indian Express, in Sakal newspaper. But the most important thing which comes from Bennett and Coleman was that the people of this country had a right to know how the decisions have been taken. Because ultimately, it is important at this juncture when we study the very important component of fundamental right, the foremost thing is the definition of state. Again, I'll quote Chandra Saab again, public authority. The dimension which Parikshit Shiroi sir rightly said, on the same day, two different analogies. Sabaji Tiwari and Sukhdev versus Bhagat Ram. In one, three institutions, LIC, IFCI, they were held state. And CSIR was not held state. After 27 years, in 2002, Pradeep Kumar Biswas the Supreme Court held that it is strict. When we try and understand the analogies which have been taken by the Supreme Court and even by different institutions, and even I would rather say I'll take a very recent judgment of 2022 from the CIC, RBI versus private banks. I'll take that particular part. It's a very interesting judgment. I'll come to that. But the point of contention is that when we started from Bennett and Coleman in 1973, and when we reached to 2022, the whole of the dichotomy, it has been observed, and it has been expanded by the Supreme Court with a qualitative verbatim. And that qualitative verbatim is that once you read the basic intention of freedom of speech and expression by the virtue of reading Golden Triangle created by Justice V.R. Krishna Iyer and P.N. Bhagwati in Maneka Gandhi case, the most important thing which come into my mind while reading that particular judgment is that freedom is prerequisite to liberty, and liberty is prerequisite to equality. And that is why, in my whole 11 years of research on RTI, I started in 2010, and my point of contention at that point of time was access to justice. Now, when we talk about all these deliberations on 19(1)(a), the foremost thing is access to justice, because right to know talks about access to justice. When people have access to justice, then only we may have administration of justice. And if there is no justice, then there is no requirement of any kind of law. The whole purpose of making constitution becomes frustrated. That is something which is important. There is no meaning. That is what Justice V.R. Krishna Iyer says. Louis Brendan, Chandra Saab referred. And I'm reminded of Louis Brendan in his qualitative intent when he said that sunshine is the best disinfectant. Now that's
and
sunshine.
Electric light is the best policeman.
Absolutely. Sunshine is the best disinfectant. Now RTI is the best disinfectant. See, this is the analogy, and this is the understanding of right to know. When we talk about Right to Information Act, and when we talk about freedom of speech and expression, as lot has been discussed by Chandra Sir, I will only confine myself to two different important parts. One is Bennett and Coleman, and another one is Ministry of Information and Broadcasting versus Cricket Association of Bengal. Both the cases discussed elaborately the essential understanding of speech and expression. And let me tell you this fact that this is not an absolute right. Time and again, everybody talks about all these deliberation time and again. You cannot write anything on the Facebook or any other social media. You're bound by Article 19(1)(a) in letter and spirit. Why? As Chandra Saab rightly said, you are bound by the words which are again given in Article 19, Clause 2, which put certain limitations. So those limitations, make it a right which is subject to the parliamentary understanding. It is something which is very much within the domain of law, which has been intended or enunciated by the Supreme Court time and again. But the point of understanding is that you cannot speak or you cannot write whatever you deem fit. Similarly, as a public servant, when you write something, on the other hand, people have a right to know because there is a note sheet. The green sheet, and on the left-hand side, all the deliberations, from time and again, from where it started, from the clerk, and to the highest echelons of public policy, the Secretary of the Government of India, it goes like that. And that is the point from where everything gets, started. Now, when policies have been decided and when the fate of an individual, when the fate of citizen is decided, then it is clear beyond reasonable doubt that when the fate is decided, there is some kind of discretion. Because ultimately the pen, you use, that pen is a discretion. Sometimes you use that pen for the welfare and sometimes you use that pen, for secrecy. And when you use that pen for secrecy, then, the whole purpose of freedom of speech and expression, it gets frustrated. Because the very foremost thing which is intended within the domain of Right to Information Act is a public disclosure, suo motu disclosure. That is what is the essence. That is what is the heart and soul of the Right to Information Act. If you want to understand the dichotomy of right to information and the dichotomy of freedom of speech and expression, then you need to understand the more we dispense information, the more there will be justice. Because people don't need to file RTIs. Why there is plethora of RTIs, and why there is a talk now that Aditya Bandyopadhyay versus Central Board of Secondary Education. The Supreme Court had to say, the misuse becomes rampant to some extent. On the other hand, we will have to keep in mind in plethora of orders by the CIC that the objective of RTI is not to gratify personal interest, but larger interest. Now, this is what is the intent. Why in Menaka Gandhi, P.N. Bhagwati said that the procedure must be just, fair and reasonable. There is a connection, and the connection is inevitable. The connection is that you cannot disclose something which is directly obstructing sovereignty, morality, and blah, blah, blah. But you are bound to disclose. You are bound to disclose every policy statement, because that is something which makes the whole of the understanding of freedom of speech and expression. Otherwise, it has no meaning. You say that you have a fundamental right to speak. What is a point when I don't have the reason to speak, when I don't have the information to speak? Information is the essence. Information is the essence. By the virtue of information only, a person, a poor man, can have justice. Otherwise, there is no meaning to justice. We have seen Union Carbide. We have seen Bhopal catastrophe. People died. Penny, was judgment. Why? Because people don't have right to know. People doesn't have that analogy of freedom of speech and expression which talks about right to know. Now, in that context, public authority becomes a very, very important instrument. Chandra Saab rightly said, and that is why, Subhash Chandra Agarwal versus CPI or Supreme Court, the judges should disclose assets. Now, this is something which is important. In other deliberations, the collegium deliberations must also be made public. Now, that is what I have said in my PhD in 2015. It is available on the website of Jamia Millia Islamia. My finding says so that access to justice is prerequisite to administration of justice, which means that the office of the CJI must come under the purview of the RTI, because ultimately we have a right to know how our judges has been appointed. Now, this is something which is very, very important. This is all interrelated, because access to justice, it involves around all three factors: the legislature, the executive, and the judiciary. You cannot say that one is totally exempted and they will not disclose. No, because ultimately that freedom of speech and expression is the essential attribute, and right to know is part and parcel of that attribute. And that is why, again, I am again reminded of a very interesting part. A very recent case, Reserve Bank of India versus Jayanti Lal Mistry. A very interesting one, In this case, it is a very instrumental case, and then I'll come to 2022 order of the CIC. Why I'm using that part, I'll also disclose that important aspect, because ultimately we are talking about freedom of speech and expression and right to information. Now, the issue before the court was whether that Reserve Bank of India as well as other banks can deny information sought by the public on the ground of economic and interest, commercial confidences, fiduciary relationships with other banks, and whether such information can be provided under the Right to Information Act 2005. The Supreme Court answered that question. The Supreme Court held that the RBI was to act in the interest of public at large, for it is a statutory duty of the Reserve Bank to comply with the provisions of the Right to Information Act 2005. The Supreme Court rejected the argument that information could be withheld in view of the fiduciary relationship. with other banks and held that the RBI does not place itself in a fiduciary relationship with the financial institutions. Now, let me tell you this fact: when the Supreme Court says so for the Jayantilal Mistry case, I am reminded of a very important thing, which again, which again draw my curiosity. And the curiosity is that why the law framers intended with Section 8 of the RTI Act. There would have been some reason, because Section 8 talks about exemptions. As I told you, freedom of speech and expression is not an absolute right. It is subject to reasonable restriction by the virtue of Clause 2 of Article 90. Similarly, right to know is also not absolute, and it is subject to certain limitations. And those limitations are embedded within the domain of Section 8, A, B, C, D, E, F, I, J, K, and so on and so forth. Under the garb of fiduciary relationship, under the guard of privacy, under the garb of sovereignty, how many informations, when they are not disclosed to the needy, it really, put the whole of the society at ransom. And I would say the whole purpose of making such qualitative act, Bentham talks about utility of law, and I think the utility itself talks about the essential ingredient of essential reasoning behind the act. When the reasoning behind the act is not understood in the letter and spirit, what is the reason of the law? Why we intended with law? Now, this is something which is very, very instrumental factor. Why the Supreme Court has to say that please disclose information, while on the other hand, you are duty bound to disclose information. And when you disclose information, you will have to keep in mind that it is a fundamental right. While on the other hand, when you do not disclose so, please keep it in mind that there must be some cogent reason behind that. When even I am reminded of another case, in the Presidential Reference number 1 of 1998, when the Supreme Court says regarding collegium system, when the Supreme Court says that if a particular recommendation from the central government, is to be particular recommendation is to be rejected, there must be some cogent reason behind that recommendation regarding the elevation of the judge or regarding the appointment of the judge. When cogent reasoning is required there, then why can't you give cogent reasoning here also? And that is why, I'm reminded of a very interesting order by CIC, a very interesting one, wherein it is again a coincidence that one of the commissioner is sitting here with us. The order was delivered in 2022, I believe. If I am correct, it is 30th of March 2022, and the name of the case is CPIO Reserve Bank of India versus Mr. Girish Mittal. In this particular order, my curiosity was solved, and the quality of the order was, it talks about public interest test. It talks about each and every essential domain of law, wherein public authority, the relation between the public authority and the dispensation of justice is directly attached. कैसे मिलेगी इंफॉर्मेशन, किसको मिलेगी, किसको नहीं मिलेगी, क्यों नहीं मिलेगी, बहुत स्पष्ट है. ऑर्डर ने स्पष्ट कर दिया कि पब्लिक इंटरेस्ट टेस्ट इज द एसेंशियल इंग्रेडिएंट. तो जब पब्लिक इंटरेस्ट टेस्ट इज द एसेंशियल इंग्रेडिएंट, बाय व्हाट स्ट्रेच ऑफ इमेजिनेशन एनी CPIO or PIO can say that we will not disclose it? You will have to disclose it. But there is a line of caution again. Again, that order, RBI versus private banks. The line of caution is that if something is exempted, there is a provision under the RTI Act, under Section 10 of the RTI Act, and that part is severability. You sever it and disclose the information which can be disclosed. You sever something which is not being able to be disclosed, that is exempted, no issues at all. Even in when we read Article 13, if Dr. Parikshit is teaching constitutional law, there is a doctrine of severability. It is clear beyond reasonable doubt, something which cannot be, something which is inconsistent with or in derogation with fundamental right up to the extent of its inconsistency, the law can be severed. Similarly, the Central Information Commission and the Information Commissioner Suresh Chandra ji rightly said, you will have to understand the doctrine of severability, and that is something which is essential ingredient. No doubt about it that the information must be disclosed, but certain informations wherein it is not possible to disclose, the doctrine of severability, can be applied. And that is what is the key. The RTI Act, is a wonderful act. It is a wonderful act because it talks about access to justice mechanism. Again, I am coming to that particular point. When you go by the deliberations mandated under section 6 and 7, wherein you can ask information, designation of PIOs is a must consideration. And when certain institutions do not designate PIOs, then there is another problem. Mark to this days, and this, and this is how 30 days completed. वो mark ही होती रहती. In this context, we will have to train people. I think there are certain orders which have been given recently by the CIC. They are very good orders. Again, it's a coincidence that Chandraji is sitting here. He was part of more often all those orders. Very interesting orders. Actually, the point behind right to information and freedom of speech and expression, the gist is access to justice. Time and again, I'll refer that. Why? Because the more suo motu disclosures you will have by the virtue of section 4, there will be less RTIs. The more you apply severability, there will be less RTIs. The more cautiously, again I'm using the word cautious, you use section 8, there will be less RTIs. And that is why, at this point of time, when everybody needs to know how it has happened, then the notion of file noting comes into play. It's a very essential ingredient of RTI. By the virtue of this file noting, you may know that how it has happened. Who are the parties who decided it and why it was denied? No, this is something which is very important. At this point of time, it is something which is very, very important. There is a rationale, and the rationale has its own significance. Why? Because nobody is beyond the reach of access to justice mechanism. Even the political parties, again, 2030s, I am reminded of another, a leading judgment from the Supreme Court, from the CIC, sorry. Subhash Chandra Agarwal versus Indian National Congress and others, where the political parties, 6 leading political parties, they come within the domain of the RTI Act or not. Now, this is a very important kind of a nomenclature. People must understand this deliberation. It has its own distinction. It has its own distinction because it must be understood in the letter and spirit in which it is intended by the law framers. That is what Maxwell said. The point is very clear. The law which is intended by the law framer must always be understood in the letter and spirit in which it is intended by the law framers, as it is. In this context, whomsoever it may be it political party, you are obliged to disclose. Because ultimately, that money, democracy is an essential attribute. And V.R. Krishna Iyer rightly said, in Rajnarayan versus Indira Gandhi, that election is a basic postulate of democracy. And when you talk about election, you need to understand that the election and its manifestations from the Representation of People's Act 1951. All those deliberation comes from these political parties, and they are accountable to the people. And that is why they must be transparent and accountable. The basic intent of freedom of speech and expression and right to information revolves around two essential ingredients. One is accountability, another one is transparency. The more qualitative orders CIC will deliver in years to come, the more qualitative orders the High Court and the Supreme Court and the different high courts, they will deliver on RTI, the more right to know mechanism will improvise within a framework of time. Because there is a lot more to be achieved. Although sometimes I am also of the mind that there are so many frivolous RTIs. And that is something, which puts the objectivity of the act in danger. That is something which is very, very important. When most of the time I talk to different PIOs while training sessions, they used to say, sir, एक ही क्वेश्चन को अलग अलग आदमी 4 बार पूछ रहा है. Now this is also not done. The purpose of the RTI Act is to access information, not to frustrate the systematic framework. And more often it has been regularly done by so many so-called advocates and so many. I'm sorry to say that, but this is a fact. Because whatever I am saying, it is all because of, what I've gathered from the PIOs. Now, the point here is, when it is a fundamental right, when it is not absolute, then in totality, it must be understood in its spirit. And Montesquieu rightly said, spirit of law. There must be check and balance, because that is something which is very, very important. That's supremacy of power, supremacy of law. Arbitrariness is antithesis to rule of law. Now, this is what is the essence. Now, this essence of arbitrariness, whenever, again, being misunderstood and not utilized properly by the competent authorities, by the virtue of the RTI Act, then people will have to face problems. And that is why, again, I am using the term, use Section 8 cautiously, being a PIO. Why there is so many pendency before the CIC and different state information commissions? I was, around a week back, I was delivering a lecture at Sagar Central University. And there were so many, it was a refresher program, and there were so many professors from different universities across India. And they were all, some of them were working in their universities, and they have seen so many problems. They are facing so many problems. So this is, RTI is meant for the purpose. Don't frustrate the purpose. No doubt about it that it has its own dimension, and the dimension is fundamental by the virtue of freedom of speech and expression. When I have a right to speak, I have a right to know. Essentially connected. And that is why in Bennett and Coleman, when people come to know 10 pages, पूरे देश की खबर कैसे हो पाएगा? We need more pages so that more information. The more information people can access, there will be more sunshine. And people will have an access to justice. People will come to know how the decisions have been taken by the authorities, because that is what is the intent. क्योंकि ये जो print media है और जो हमारा जो इलेक्ट्रॉनिक मीडिया, इसी के माध्यम से हमको पता चलता है कि कैसे डिसीजंस हैव बीन टेकन. तो कम से कम हमको पता चलेगा, फिर हम देखेंगे कि उसकी यूटिलिटी क्या है, हम देखेंगे कहाँ खामियां हैं. RTI एक इंस्ट्रूमेंट है, इट इज एन इंस्ट्रूमेंट ऑफ चेंज. लेट अस एक्सेप्ट इट एज एन इंस्ट्रूमेंट ऑफ चेंज. It is a very, very important, essential element. And when the elements of justice they are to be understood. They are to be understood in the spirit of law. The spirit is justice, equity, and fraternity. That justice can only be achieved because justice, it is something which is an essential attribute. Justice can only be achieved when it is available to the masses by the authorities. I must say at this juncture today that we have the best Freedom of Information Act, which is known as Right to Information Act. I have made a comparative analysis with the Freedom of Information Act 1966 and Freedom of Information Act Australia of 1982. There are so many exemptions, class exemptions in the Freedom of Information Act 1966 in the United States. And let me tell you this fact that our act is far better than any other act in the whole of the world. Even Britain do have this act. And I must say, the yeoman work Central Information Commission, High Court and Supreme Court is doing in dispensation of justice by interpreting law for the masses when it comes to Right to Information Act is something which is tremendous. It is something which must always be appreciable. We must appreciate the pain taken by the Central Information Commission in dispensing justice to the masses, ultimately at the cost of ₹10. It's a huge population. Some people will say, "हमको 2 साल लग जाते हैं साहब, हमारी तारीख लगती है." But you must understand that it's a huge chunk. We are a huge population, but still तारीख लगती है. और still justice delivery होता है. अभी recently मेरे एक मित्र का, उन्होंने 2 साल लगे उनको State Information Commission में, but उनको information मिली. This is the quality. This is the class. We must not forget the very essential, basic ingredient: liberty. Liberty of press that was taken by the Supreme Court. That liberty, when you attach that liberty with the basic understanding of right to information, you come to know that it is also, it's not, yes, no doubt about it that there are certain reasonable restrictions, but again, you get liberty to know. I would rather say it is not a freedom. I would say it is a liberty, because ultimately you won't get that liberty anywhere in the whole of the world at the cost of ₹10. Let me tell you this fact. This is something which is very, very essential. And this is something which we must all respect because we are in a democratic framework. It's a fundamental qualitative right. Let's respect it. Let's not misuse it. Let's understand the deliberation of freedom of speech and expression. Respect all. Write something which is qualitative in essence. Don't write something which hurts the sentiments of others. Please respect all. This is what is the intent of freedom of speech and expression. And please ask information when needed. Please don't ask information when it is not needed. Thank you so much. Thank you so much for giving me an opportunity to speak. Thank you.
Thank you. Thank you very much, Dr. Varun. Excellent points which have been made by you. And we will come back to you on file notings, because that is something wherein people seem to have a lot of questions. Before that, I would like to come to first Suresh Chandraji, and then to you, Varun, on the same thing that our participants would like to know from you as practitioners as to what are your suggestions for strengthening of the act. Sir, first to you, sir. Suresh Chandra, sir. Sir, you are on mute, sir. I will just request you to unmute, sir.
Thank you. A very good question. When I say strengthening, the foremost important thing is we must educate people. Those who are seeking the information, those who are giving the information like PIOs, and at the same time, those who are dispensing with the appeals. That also. There is a need, number one. Number two, we can strengthen it by suo motu disclosure, by more use of Section 4. wherein we can categorize, and most of the information, whatever is there in the form of reports, in the form of annual reports, whatever, we put it in public domain. There is no need of any seeking information. And lastly, I will say that is, though it is a part of education, but still there are a lot of people who do not know, do not understand as to whether this is the information in material form, or it is a question, or they are seeking legal advice under the garb of RTI application, or they are seeking calculations, certain things, or they are trying to find out where the law is. It is not the function of the CPIOs, nor they are inquiry officers. This is required to be educated. And I think if we can do, now for your information, I want to share our filing of RTI cases, appeals, is less than our disposal. This is happening for the first time. And even during the, for last almost 2 years, this trend is there, that the filing of the RTI appeals are less in number than the cases which are being disposed of.
That is fantastic. Absolutely, sir.
Yes. And number two, I will say the quality, when it is the quality of, orders, quality of the judgments of the CIC. Even in Thalla Pallam case, the Supreme Court has accepted that the final arbiter is the CIC, Central Information Commission, or the State Information Commission. If higher courts have to see, again they have to see, not to substitute the wisdom. Of course they can do it, but that is the message. So Mr. Varun has not especially, explained our order, which is a kind of on Jayanti Lal Mistry, I don't know. But I wanted to hear whether he liked it or he did not like it, but he did not tell that part. Because what we have done, what we have said...
We can ask him now, sir, no problem. After
yes. Some of the persons, they may take it that it is a retrogative. But for some of the persons, because we have tried to find out the ratio of the Jayanti Lal. That is the only best part of our order. And the person, that is Grish Mittal, was asking only on the strength of that judgment. He was not talking of the exemptions, he was not talking of anything, this, blah, blah. So to that extent, I will say we have distinguished it, we have laid down what is the ratio which has been laid down in that, and we have not violated it. Maybe some of the persons may differ it. But what I am saying is, the quality of order, if are good, this will help the high courts and the Supreme Courts. I have not come across for the last 2.5 years that my single order has been reversed. Lot of orders have been challenged, but not a single order has been, reversed. That should be the quality. That should be the quality of the CPIO's orders. That should be the quality of the First Appellate Authority's order. That should be the quality of the information commissions. If that happens, then we can definitely bring out, efficiency and effectiveness in implementation of the Act. Apart from that, I concluded, there is a provision of monitoring by the Central Information Commission. Monitoring and giving recommendations, blah, blah. That part is not being properly, perhaps exhausted by the commissions. Reason being, most of the time we are disposing the appeals 20 cases, 25 cases a day we are deciding. We are not like, high courts and Supreme Courts or the civil courts, which are cases are pending for decades together. If you see our cases, there are cases, around 20 cases, each commissioner nowadays hearing, and we are disposing of finally, except 2 or 3 wherein we are giving so cause or we are adjourning because of the non-appearance of parties. That is the beauty part. So that monitoring, and here I use my good offices and persuasive forces here. Dr. Parikshit, I tell you, our Prime Minister, he is a visionary to the extent when he first spoke on 15th August 2014, he spoke about interdepartmental disputes. You might have then there were some of the judgments. Now very recently he had spoken about this citizen-centric approach by the courts towards the under trials, towards the arrest, and towards disposal of cases. Now again, he had said very important thing, which people will never come to know, which as a law secretary I came to know. And that aspect was in a meeting, 2-3 officers meeting, we were discussing about the overreach. When the Supreme Court gave a judgment that within 500 meters there will be no wine shop on the highways and all that.
Yes, sir. Yes.
Now, on that, he spoke very important, very, very good point. He said, is there any mechanism whereby we can understand at the time of a conflict or dispute or court case, or even after a court case, as to whether there was a fault of the law or the fault of the person who implemented it, or the judge who gave that judgment, or the petitioner who filed it. I tried to convey him, we had certain institutions like Law Commission, like ILI, like our Professor Varun Chacharji, who are analyzing, giving a critical analysis of everything, our judgments also. Somewhere that, that approach is lacking somewhere. Either we are writing very appeasing, or we are preparing in ILI, in some other institutions, these speeches for the Supreme Court judges, or for going for valedictory functions, substituting, the professors and all in awarding, degrees and becoming the vice chancellors and all. Somewhere I tried to tell him there are certain institutions which are not working with the optimum, capacity or in a right direction, or maybe we are not utilizing, like Institute of Constitutional and Parliamentary Studies, like international, law, what is that, studies near ILI.
Next to ILI, yes, sir. ISIL.
To ILI.
ISIL.
Like this Legal Service Authority, we brought out this, and now this is being now headed by not legally trained persons. Like those people, you can't understand when we have been derailed. The access to justice has been really derailed on papers, in speeches, in books, in Supreme Court judgments. Every day you can find that the Parliament should make this law. They should bring out new law on what you call on the arrest. They should bring out a new body for infrastructure development for the courts. They should bring out some. See, the question is, everybody, whosoever is assigned his own job, they should discharge their duties with full devotion. Instead of introspecting themselves, they are trying to find fault with the parliament, or finding fault with the law ministry, or finding fault with the I will say the professors who are not sending good law graduates for internship. So I'm I'm of the view that there is a need of sensitizing, and especially these are the words which are coming seldom, which are coming from the top bosses. There is a need to work on that, as to whether we should review all those judgments wherein the Supreme Court has outreached, or there is a activism, judicial activism. Where is the fault? Let us. Nobody is doing. Law Commission is not functioning. ILI is not properly doing their research. Otherwise, ILI was every year, when it was envisaged, they were envisaged with a view that every year they will come out with a book, review of laws, review of functioning of the laws. As there was a commission for reviewing the functioning, working of the constitution, likewise the ILI is a permanent body to review the functioning of the laws. And there they can use the resources which are coming from the universities, from their researchers. Lot of money is being given. I was instrumental when we enhanced the grant from 25 lakhs to 1 crore when I was OSD to the minister, Mr. P.R. Kumar Mangalam. So these are the institutions which are now sleeping. There are mechanisms already in our system, checks and balance. As Dr. Varun Chacha told, we have various audits. If you are not doing your own, if you are not putting your own house in order within internally, then there will be external body like CAG or like the Supreme Court or High Courts. They will put you in order, but it costs burden on the public exchequer. So these are the words.
Thank you very much, sir. I will just move on to Dr. Varun. What I will do, in the interest of time, I will just club the questions that are there for you. First question for you, Dr. Varun, is the same which was put to Suresh Chandra sir. What are according to you, what can we do for the improvement of the working of the RTI? That is the first question. Second question comes from Madam Ranjana Day. How far do you feel the armed forces are correct at seeking the blanket exemption from RTI? And the third question is regarding file notings, which somebody was asking me today, and I thought that it would be best if I put the question to you since we are meeting today. So this is actually with regards to file notings, and as you know, in every case, most recently I think in the Rafael case also, the whole issue was that there were file notings which indicated some parallel negotiations and so on and so forth. So what the authorities have been doing is that they have been taking recourse to the RTI Act says that according to 2F, the information means any information, records, documents, logbooks, emails, whatever. So file notings is within this purview of 2F. And but what the attempts have been made to not to disclose, even within the UPA time, it was there. And then I think the Delhi High Court in 2018 has ruled in favor of an RTI applicant who was not given the file notings with regards to something that happened, report sent by the Karnataka governor to the Union Home Ministry when the political instability was there in that particular state. So they have been trying to use Section 8(1)(e), Section 11(1) to withhold the information. So, would you like to talk about these three aspects. So one which has been posed by Ranjana ji regarding armed forces, one regarding improvements in the act, and one regarding file notings, please.
I will start with Ranjana ji's question. Uh, as far as my view on this particular aspect is concerned, I'll just go by the intention of the legislature. There is nothing in the act, which directly or indirectly affect anybody. And let me tell you this fact that this particular debate, which has started sometime in March, wherein a blanket exemption was asked by the armed forces from the RTI Act. I think it is important at this point of time that the veterans and the soldiers, there are a number of questions they do have from the authorities regarding their pension and other issues. I don't see anything wherein the armed forces require any kind of blanket exemption, because ultimately, there is a notion of accountability and transparency, whomsoever it may be. If a blanket exemption is being given, I have a very serious reservation regarding that particular thing, because ultimately, where will those veterans go? They have fought for us. They are the one because of whom we are here. So, agar situation would be this, that they won't be able to know what their pension is, what their arrears are, then it becomes very difficult task. So, my personal view is that there must be it should not be given. A blanket exemption should not be given, because the whole purpose of the RTI Act gets frustrated if you give such kind of blanket. Because today it is armed forces, tomorrow every third authority will say that, look, we need a blanket exemption. No, this is not done. We have Section 8. I think Section 8 fulfills all the requirements. We don't require any more exemptions as of now.
So my concern is with regard to the leeway that the armed forces can get in hiding information about the entire procurement chain, the supply chain, sir. Because we know how much our defense ministry
I got your question. Your question is why blanket exemption. That is what is your intent. So I have answered this. Personally, I feel there should be no blanket exemption. That's it. No blanket.
Fair enough. So will you, Dr. Varun, just dwell on the other two questions?
Yes.
Also,
now the next question is file noting. I'm reminded of a very important judgment. Way back in 2011, Union of India versus R.S. Khan by the Delhi High Court. And I'm reminded of that judgment wherein the Honorable High Court gave an eye-opener order, wherein they say that the concept of file noting is part and parcel of Right to Information Act. And there is no such exemption by whatsoever, understanding you have. If you try and understand the exemptions, it is clear beyond reasonable doubt that the exemptions are express exemptions, and there is no requirement of any kind of implied exemptions. And by no stretch of imagination, you must read file noting as implied exemption. And the Delhi High Court has made it clear, and even the CIC, I'm not reminding the order, when Chandra Sahab was there in the order, he gave a very good order, wherein he talked about file noting, and he said that, it is part and parcel of the Right to Information Act. And even CIC has also given quality orders in this regard, I must say. Now, in this context, I think, as I have rightly said, अगर वो हरे रंग की शीट के बारे में पता नहीं चलेगा तो गवर्नेंस तो इंप्रूव हो नहीं पाएगी. तो मेरा मानना यही है, और इवन यही लॉ ऑफ द लैंड भी है, कि फाइल नोटिंग is part and parcel, of the Right to Information Act. There is no question at all. Now, another question you talked about, what is required for the
effectiveness. Yes.
Effectiveness. I believe, Dr. Parikshit, I believe awareness is the essence. As Chandra Sahab also rightly said, the more we make people aware about right to know, the more they will understand what ought to be and what not ought to be. Because this is what is the essence. This is what is the intention. पता होना चाहिए क्या होना चाहिए क्या नहीं होना चाहिए. क्या मांग सकते हैं क्या नहीं मांग सकते, कैबिनेट पेपर आप यू कैन नॉट आस्क, सीधी सी बात है, एक्ट में लिखा है, आपको समझना पड़ेगा उसके पीछे की इंटेंशन क्या है। इट्स क्लियर बियॉन्ड रीजनेबल, सर्टेन प्रिविलेजेस आर देयर। नाउ व्हेन द प्रिविलेजेस आर देयर, दे आर विद द इंटेंशन। 105 है और there is an analogy of the Supreme Court. Supreme Court interpreted it. Anything means everything. This is what is the intention. NKP Salve, I don't remember the name of the case. YB Reddy, it's a very famous case. So we need to understand the dimension of law. And the dimension is that more awareness, more understanding about what can be asked and what cannot be asked. And we also need to understand that we are in a democratic framework. Every decision is taken by the public authority, and public authority is answerable to all. They will have to answer. There is no escape. There is no escape mechanism. Hence, a note of caution from both the sides. One side, no misuse of Section 8 of the RTI Act. From the PIO side, from the First Appellate Authority, and from the applicant side, you need to understand the purpose of the act. You can seek information, you cannot ask reasoning. Grievance redressal mechanism thodi hai. It's not a grievance redressal mechanism, by the way. Right to Information Act purpose is to seek information. That's it, nothing beyond that. So we need to understand this particular. Any other questions?
Yes, this is fantastically put. In fact, that is Sham Sundar versus NKP Salve
Absolutely.
Institute of Medical Sciences. That is the case.
Absolutely.
And if my memory serves me right, that is being given by the commission sometime in 2015 or 16, something like that. So the last question that we will take, and I think this one should be put to Suresh Chandra sir. Sir, in your own capacity, what do you feel about the 2019 amendment? A lot of people seem to feel that the 2019 amendment reduces the effectiveness of the RTI. And a follow-up, which a student of mine is also asking, what can we do to protect the life of the RTI activists? So if you will just give an answer on this point, sir.
I think if you don't ask this question to
I
me,
I understand, sir. I understand.
One thing I am telling you, had I been there as a law secretary, the things would have been different.
I think that much is enough, sir. That much is.
I had at various levels, I had used my power of positive and persuasive forces not to do things which are not in larger interest. But sometimes there are people who are not able to present to the authorities. This is something, and but see, one institution can be of Supreme Court level. They have made Supreme Court to lower level. There can be quasi-judicial body at the district level. That is not my issue. You can give them more pay, you can give them less pay. That is up to you. But compromising the independence of a body which is a quasi-judicial body, that is something which needs to be, but I will not say anything.
No, we understand. We understand that is the freedom which is available to academicians. So we will have Dr. Charcher speak on it. I knew what your personal views were. I just wanted to share if you were comfortable
Dr.
with the. Yes.
Way back, I believe in 2017 or so. In 2000.
No, we must just put one thing in perspective. Suresh Chandra ji said that probably this could have been handled better. There have been previous attempts also to dilute the effectiveness. So those
This is one aspect, and second is other aspects. Now I'm here for last 3 years almost, and you see, the commission is not in very, not in news that way. If commission is in news, then it is in news that we are bringing down pendency, our orders are not being challenged and all that blah blah. But there was time when some of the people who were not basically, I will say, not judicially trained, they were passing the orders without the prayer. Lot of. Now you people, I cannot think of, unless something is prayed. How can I? Give an order. I become a party to that. So these were also some of the reasons, I will say. So both way.
Correct. So fair enough.
Yes.
Thank you, sir. Yes, Dr. Varun, please.
Yes, Dr. Parikshit. I believe in 2020 I published one paper, from the Law Center 1 on this particular amendment.
Joltai.
And in that particular paper, I have given two approaches on 2019 amendment. My first approach was, does it make any difference by reducing the rank of the commissioners? Does it make any difference on the dispensation of justice? That is question number 1. And my question number 2 is whether access to justice mechanism may be impacted by the virtue of reducing certain powers of the public office of the information commissioners. Answering my question number 1, I have made it clear that there have been certain attempts previously also. But those attempts were never fulfilled. Now, when this 2019 amendment was made, I have not seen any change in the qualitative dispensation of justice in the Central Information Commission. They are qualitatively dispensing justice. Though there may be certain questions regarding the independence of a quasi-judicial body, no doubt about it. Yes. And that should have been taken care of by the legislatures in a very careful manner. Right? Every day I used to analyze different orders by the CIC. I believe the Central Information Commission is doing a yeoman task in providing justice to the masses. I think they should not bother about the rank. They should bother about access to justice. And they should bother about administration of justice. On the other hand, the legislatures must also respect, the independence of the quasi-judicial bodies also, because independence of judiciary is an essential attribute to administration of justice. Time and again, from SP Gupta to Supreme Court Advocate on Record Association 2015, the Supreme Court said so. I believe the same analogy which has been adopted for the Supreme Court should have been adopted. I'm again saying it as an academician, should have been adopted for the quasi-judicial body called the Central Information Commission. That could have been much better.
So thank you. Like I said, this is the freedom which we as academicians have. I have also written out the same in a chapter which was published by Routledge. And so in a book, in fact, the book was ominously titled Institutional Decline. So I have written about this particular aspect when I was talking about the CIC. So thank you very much. I think that was an excellent discussion. If there are any further questions from any of the participants, you can just email us and we will try and get you the responses. Both Dr. Varun and Suresh Chandraji are highly accessible, and we will definitely try and get you the best possible answers. So I would just like to invite the program coordinator, Sumiti Ahujaji, to deliver the vote of thanks.
Thank you, Dr. Sirohi. Very good evening to all. On behalf of Law Center 2, I take this privilege to propose today's vote of thanks. I would first of all like to extend my gratitude to Sri Suresh Chandra ji for sparing his valuable time and gracing this occasion. He has shared with us his significant opinion on a topic which is relevant to the interest of citizens, and RTI being a crucial pillar for the functioning of a transparent and a vibrant democracy. He referred to preamble as the key, and he specifically highlighted liberty in the preamble. Thank you, sir. Uh, my heartfelt thanks to our own proud alumnus, Dr. Varun Chachar, for agreeing to be a part of the Golden Jubilee celebrations of Law Center 2. He has enlightened us with, thank you, sir. He has enlightened us with his immense knowledge on the subject, which is of great importance to all. He rightly pointed out that context makes the difference. In fact, I also, Dr. Chachar, I also teach interpretation of statutes,
Oh, great.
and I keep on repeating this thing in my class as well. So I definitely agree with you on that. And sir also raised an important issue